I'd like to quickly, thank you very much, sir. I'd like to quickly call on Barrister Bangoye, Babatunde Bangoye, representing the National Commissioner of the Nigerian Data Protection Commission. He will be giving the keynote address and will be opening the workshop for the day. Please, a round of applause as he stands to give his keynote address. Thank you.
The Secretary General of the Committee of Vice Chancellors, Professor Yakub, my brother on the high table, Ambassador Olugbile, Deputy Vice Chancellors, Principal Officers of the University here present, every member of the academic community, my colleagues from the Nigeria Data Protection Commission, and members of staff of the of this great committee. I bring you good tidings from the National Commissioner, Nigeria Data Protection Commission, in the person of Dr. Vincent Olatunji. If you knew the person of Dr. Vincent Olatunji, you will know that he would have loved to be here in person. He is a doctor, not just an ordinary doctor, honorary, just an honorary doctor. He's a PhD holder. So he's a person of, letters himself. He honestly wanted to come. But other national engagements, as Ambassador said, this data is just issue now. I was even dragged also from another engagement to be able to represent the National Commissioner this morning as well, because of how much we esteem the academic community and how much we want it to be the cradle indeed of what we do in terms of advancements of data privacy and protection. So on that note, we want to thank you once again for coming. Indeed, I'll be doing two things this morning. So the goodwill message will flow into the lecture, as it were, and it's not going to be a lecture. Permit me, it's going to be an interactive section, because even if you don't know data protection, I still respect you as professors and men of letter and women of letter. So no matter what, you will have something about data privacy and protection. You will have something for us to learn also from you. And so it's going to be an interactive section as much as possible. If you had come with the thoughts of just hearing and listening, please perish that thought. It is going to be engaging. We have to engage ourselves. We have to learn from you what we need to stop, what we need to start, and what we need to continue, as the case may be. So we want to take some lessons home. Data privacy and protection is something that I believe we are all familiar with. And just like we have said earlier this morning, even though Ambassador Olugbile said, you should fear me, but I want to say that please don't learn, don't comply out of fear, but comply out of the fear of not being compliant, because that in itself is the real problem. Data privacy and protection is something that we are all familiar with, one way or the other. And anytime we meet with our colleagues, especially in the advanced world, I do tell them that Nigeria or Africa is not alien to the idea of privacy. In fact, as a Christian, I had to do my research in the Ifa corpus to know whether we have something about privacy in the African community. So I'm a researcher myself. To go deep, do we value privacy in Africa? And I looked at it. I realized that we indeed value privacy when you look at the way we construct even our homes. You can go to the north and see the way they construct their home, and you go to some other parts, you will see that the north, there is a way it is that there is privacy before now. Is that correct? and you go to the African society, the average African society, you know, every part of the community or every part of a house is separated from the other way or the other. But when you look at the modern communities, you see that you can have a room or you can have an apartment is as big as where we are. The kitchen is there, the bedroom is there, the living room is there. You can see almost everything in the same place. So they don't even have the type of privacy that we have. So we should be at the forefront of the idea of privacy. If only we knew what lack of privacy can cost us. So that is why even before the coming on board of the commission, we had in our constitution what you call the 1999, that is the 1999 Constitution of the Federal Republic of Nigeria, Section 37, that talks about the privacy of citizens, their homes, their telephone conversation, their correspondence, and telegraphic communication is guaranteed and protected. That is already in the Constitution. Go back way, if you have lawyers in the house, 1948. You also have it as part of the Universal Declaration of Human Rights. You go also up to 1976, the Covenants on Civil and Political Rights. They talk about data privacy, talk about privacy in general, the need for us to protect it. And the first global, framework for privacy was the Convention 108, which came in 1981. Then much later, you now have the European Union General Data Protection Regulation, and that marked the turning point for all of us. Why did it mark the turning point for all of us? It means that if a university in Nigeria or a higher institution in Nigeria wants to have an exchange program with another university out of Nigeria, they begin to ask questions on privacy and protection. Their students are coming. Are we sure that their information will be protected? We want to share information with you. Are we sure that this information will be protected? And it is even possible that for some reasons, some of them are still not asking these questions, but they have started already. As a matter of fact, Nigeria itself, as a sovereign nation, was asked to go.
What are you dropping the file on my table for? He said you told her to come and drop the file on my table.
A data privacy commission, the data protection commission. Why was Nigeria asked that question? Because Nigeria wanted to embark massively on digital identity, what you now call NIN. And they needed funding from the World Bank. They needed funding from the French Development Agency. They needed funding from the European Investment Bank. And all those people said, we are not going to give you this funding unless you have that commission in place and you have an act in place. We will not allow you to go after your citizens to begin to collect their data. And that is why the commission was established. So this is just the goodwill message that we want you to take home. And in the course of our discussions, we will go more technical into the idea of data privacy and protection. So on that note, we declare this workshop open to the glory of God and the benefits of mankind.
Thank you very much, Barrister Bangboye, for that keynote address and for opening the workshop officially. So quickly look at our agenda for today. You see we're supposed to take photographs and tea break and networking, but since tea break is going on, we'll just go ahead and move to the overview of the act, which was from the program. We have Yusuf Akinde. It's from the NDPC, but Barrister Bangboye will be taking us on that section for the overview of the act. So quickly, we'll just go right into it. So a round of applause as he takes us again.
So at this stage, permit me to now come down to show, most of you are even more than old enough to be my lecturer. Now the table has turned. I'm sure I'm from Obafemi Awolowo University. Great event. I'm from OAU,
great.
it's good. I knew what we went through in the classes and how important it is for us to interact with our lecturers. I think over 3 months or so, we have been receiving visitors from the academic community. And we have been participating in various academic community. It shows how proactive that the community is. But the practical aspect of this proactive or the theory remains to be seen. And that is why we are here. At some point, perhaps you may have seen in the newspaper or heard on the news that we were investigating a university. Why were we investigating, or why are we investigating that? There was a data breach. There was a data breach. And when we invited this university, why is it that you had this data breach? They simply told us that no, it wasn't something really secret. It was just about the personal data. Our academic records are secure. And we were shocked. It means that to the university community, the academic record is more important than the private record of the members of staff of the academic community, as well as the students. Their medical records, sensitive personal data. No, you could access all of that. The passwords, the financial records, you could access all of that. But when it comes to academic the academic records, that nothing should tamper, turn B to A or turn F to something. Nothing should happen to that. You are good at confidentiality, integrity, and availability of data when it comes to academic records. But when it comes to every other thing, this is a problem. I still got a message from one of our colleagues from Nairobi, Kenya, who are the Strathmore University. I represented a commission there. It was a knowledge exchange program in the East Africa on data protection. So they invited Nigeria as part of those who will participate in that project. And to be honest, they sent me a message recently that they want to partner with some universities in Nigeria, and this is something. Don't let me go into the details. It is something on data protection. It shows you how much these individuals are thinking about data privacy and protection. What have we done in Nigeria? Let's give you an overview of the act. Please, can you just project the act? Yes, just leave it at that. Now, the act has 12 parts, covering objectives, covering registration, covering territorial application, covering principles, covering lawful basis, covering cross-border data transfer, what you will rely on in exchange programs or other partnerships with other institutions.
Is there any time I need to touch to
Nigeria.
see this thing?
It covers all of that. It covers enforcement. It covers registration, obligations of data controllers and data controllers and data processors of major importance. These are things that you will find in the act. But in drafting the act, we were guided by 3 key things. We had a compass. Please, let's proceed. Around equity, around trust and value. And I believe these are things or principles that you value in the academic community. Trust. If a university sees, maybe they want to admit somebody to take a course in another university, can they trust that what they are receiving from you actually is a proper record? Why is it? There is someone that in those days, it used to be difficult for somebody who studied in the US to be a lecturer in Nigerian university. Can we remember, I believe the older generation here can remember that time. If your academic record, your certificate is from the United States, it will be difficult for you to get employment as a lecturer in Nigeria. If your certificate is from Eastern Europe, like Ukraine and all those USSR, it will be difficult for you to employ you. The only education they value were those from Oxford, from let's say Harvard, from the UK. That was the only certificate properly valued. You are from Europe, you are from this jurisdiction. Why? Because of the integrity, the level, the depth of knowledge. But today, even for a professor, I'm talking about life experience, for a professor from Nigerian University to practice, even in the United States, the kind of work that an undergraduate would do will be difficult. You have to take test upon test upon test to qualify to even do what an undergraduate, or let's say just a fresh graduate would do. So you are a doctor from Nigeria, you are a professor. For you to become a nurse in the US is a lot. That speaks to trust. The value of data, we took that into consideration. As we are here, Google and everything, how many of us are wearing smart watches? Where some of us are wearing smart watches, Internet of Things. Your phone, even if you are not wearing smart watches, your phone, maybe you haven't been here before and you put on your location data. Even without the location data, Google is also gathering data. How much time you have spent here, the people you are meeting with there, your phone is interacting. Now, how much value do they place on this data they are gathering? How much value do they place on other data collected elsewhere that are similar to this? How much benefit we derive in all of this? And of course, equity, which talks about access to data. Access. How easy is it for you as a researcher or as a university community to access data just the way your counterparts in other jurisdictions are accessing this data? Equal access to data, that is equity. These are the things that we have put into consideration, and I'm even happy that Ambassador Olugbile is here because it was part of the review committee for the act, and he knew how much we fought together to ensure that we can have an act today that Nigeria can be proud of. And I say this without any spirit of immodesty. We have been to UK, interacted with the ICO, our counterparts, Information Commissioner, Canada, what is this country again? Finland. And we have interacted with virtually these data protection authorities around Europe, Canada, and East Africa, even Ghana. Some of us were in Ghana also on this. What they have said is that Nigeria has the most progressive as of today. I don't know of tomorrow. And it is not just out because our people are smart, but probably also that we had to leverage on what was on ground. So Ghana, I think, had their own act in 2010. The ECOWAS supplementary act on data, personal data protection came in 2010. I think Ghana was 2012. The EU GDPR came in 2016, but came into force in 2018. Now, there are certain technological advancements that took place between that time and when the Nigerian law was passed in 2023. So it was only natural that if we were smart enough to incorporate some of these ideas when we were coming up with our laws, and they confessed that indeed Nigeria is really, really very progressive when it comes to data privacy and protection. Please, let's move forward. I will cover this message in a bottle in a bit. Now, these are the parameters. If you didn't take many things away from all that we have been saying, please, you need to know the parameters. As academics, I'm sure if you want to do your research, you have to set certain parameters, isn't it? These are the things I want to do. These are the things I really don't want to do. But as I said, there will be this class will be engaging, isn't it? So I need to ask the class question. What type of principles do you think we should have in place? Let's start. Who wants to give an idea? No answer is wrong. Let me tell you. Anything that is about fairness, anything that is about ethics, it can be wrong. So, who wants to give a try? Principles. What type of principles do you think we should have in place when we talk about protecting data? Yes, sir. I'm happy. I'm here. I'm getting the first response from Ife.
One of the principles should take into consideration our local peculiarities.
Yes. Principles are about our local peculiarity. Please, a round of applause. All right. Any other principle? Yes. Principle of fairness. Please, a round of applause. Yes. Another from Ibadan, DVC, sir. Confidentiality and anonymity. A round of applause, please. And then we should close this class now. Yes, sir.
Integrity.
Principle of integrity. Fantastic. A round of applause. Yes. Please go ahead, sir. Principle of human rights. Another round of applause. Why are you saying we should come and teach professors? All right. Please, let's give it to our mommies there. Yes. Principles of equity. Yes. Inclusivity and diversity. Another round of applause. A beautiful one at that. All right. Okay, sir. Principle of data transparency. It's inexhaustive. Let's just close it at that. To be honest, you are all right. What did I say? You are all correct. That is the truth. The only thing left for the commission to do at this stage is to see how do we integrate all these principles such that when we are interacting with the other people with their own laws, they won't say, these your principles. Maybe I say different from our own. Oh, permit me, this is academic, but sometimes I'm going to speak pidgin English. Do you understand what I'm saying? Yeah? Now, by the time we are speaking with people from Togo or Cote d'Ivoire, they will say, you seem to have, 100 principles. We only have, we have 200 principles. And you didn't cover this area. You didn't cover this area. Is that not correct? Is that not correct? So what is left for us is to, integrate all of these principles, reduce them into something that is interoperable. How many of us have heard that word before? Interoperability. Something that is interoperable. So when you are having discussion with Harvard University and you are talking about principle of fairness, they understand that you are on the same wavelength. Is that not good? So when you are talking about principle of our peculiarities, they will understand that we are on the same page. In actual fact, the principle of local peculiarity speaks to the idea of data sovereignty, cross-border data transfer. That in our own case, we are Nigerians. This is how we want our data to be treated. So even if you haven't seen it in the principles before that there is local peculiarity, whenever you come across data sovereignty or data localization or data residency, it talks about peculiarity of the people. In actual fact, around 1950s, when there was going to be a cross-border transfer of data between the United States and Canada, and the data was moving from Canada to the United States, the Canadians, they had this challenge with cross-border, this same principle of peculiarity that, look, what will happen to our heritage? What will happen to the performance of government functions? How will our citizens redress their rights if our data is located in Canada, in the United States? So they have these questions. So for the purpose of interoperation or interoperability, let us just reduce this principle into about 6 or 7. And the first of this is data should be processed lawfully, fairly, and transparently. Lawfully, fairly, and transparency, whichever order, or transparently, lawfully, and fairly. And what does that mean? And I'm sure that even by your own practice in the university community, you already implement some of this. For instance, you want to grade somebody to become a professor, be a professor, or you want to become a PhD, you call examiners, isn't it? You throw it open. If I'm not okay with the way you mark my paper, probably I can call for my paper again, and then they can set up a panel to review whatever has been done. That is about transparency. Lawfully. What is it all about? It means that it is done according to the law. It is done according to the law, that there is a law on ground. And as a matter of fact, I think maybe, do you have private universities here? Okay, virtually all universities, all public universities, they have enabling act, isn't it? Establishment act. It's something that allows you to carry out what you're doing. That is lawfulness. And then fairness. This fairness thing, it is something that I think that this is where my brother here, my old guy is my Egbo, that will agree with us that it is something about law. How do you construct transparency as a technology person? Yours is about the real ICT work. But when it now comes about transparency, why do you want to bother an engineer or a scientist with the construction of what is transparent? It is the law that tells you all these parameters. So what is fair? That speaks to data ethics. Data ethics. That speaks to what? Data ethics. The obligation that you impose on yourself beyond what the law has imposed on you, to make sure that the data subject or the person that you are processing his data understands what you are doing. And before I proceed further, I think it is important to explain certain key terms. I have mentioned, for instance, data subjects. Who is a data subject? Do we know that? Who a data subject is?
The individual whose data is being protected.
Yes, that is the owner of the data. Therefore, even the academic records that you have, that you keep, that you so much cherish, belongs to the students and is entitled to access. What is your own position in this? What are you called? Of course, you are the university, but like I said, for the purposes of interoperation, you are regarded as a data controller. Assuming you process this data, there is a platform, let's say Microsoft provided a platform upon which, or Google provided a platform upon which you can process this data. as a university or a higher institution, that Google or Microsoft, they are the data processor. Maybe they provide you with the cloud support services. They are the data processors. Maybe you, after gathering or collecting the data, you store it in a data center. They are your data processors. They are the ones who act on your behalf, who carry out the instructions of the data controller in terms of data processing. You, as the university or the higher institution, do you have, vice chancellors? I want to believe that they are only universities, right? Yeah. All right. So as the university, you are the one that determines the purpose for collecting the data. So much for the first principle. Another principle to look at is the principle of purpose limitation. Purpose limitation. How many of us will recall the story of JAM? By the way, we invited JAM. We are investigating what happened to that student or to that candidates, that minor. Now that you collected, went to a business center or computer test center to go and register, and somebody in the center was trying to reach out to the young girl, a minor for that matter, to have an affair with her. Can you imagine? Has that not gone beyond the purpose? How do you ensure that when you are the university administrators, when you engage lecturers, young ones or even old ones, they process data only for the purpose of marking, not only for the purpose of having liaison with the students, with the female students? Hasn't that gone beyond the purpose? And this is also something that we should be worried about. So there is purpose limitation, that you don't allow data to be used for any other purpose beyond what it has been processed. I mean, beyond why it was collected. And then you have principle of accuracy. Collect more than what. Can you see that these principles that we are bringing together, they reflect what you have suggested earlier? But we are only codifying it this way because of what? Interoperability. So you should have a reason. That is why you understand, that is the way to understand why they are there. They are called those. They must be interoperable. Now you have storage limitation. Storage limitation. You collect data for various reasons, and I will be happy that if after God sparing our lives, if I return to my university after 50, 70 years, and anybody, maybe I'm contesting, they still want to ask whether I was once a student of Obafemi Awolowo University. Yes, the university should still have my record. I will pray so. But there are some records probably I have at the university. I say, why are you still having this record? Isn't it? There are some records that the university shouldn't keep about me anymore after some time. Maybe record of Aluta. Okay, I was a young, gentle student when I was on campus. Isn't it? Maybe I participated in some protest or some other, things. We were young, maybe not too young though. But then not all records should be kept infinitely. There must be a reason for it. You must, because the more data you keep, the more liability you have. The more responsibility you must protect. Gone were the days when we should see transcripts. We should see transcripts of students being used, not transcripts, maybe question paper or whatever we see, that being used to sell akara. It should never happen. Now, I will say something that will shock you. How many of us you have watched Home Alone? Have we seen Home Alone?
Báwo ló wẹ̀?
The movie.
Wọ́n gbọ́ mú títí.
I saw it in another light with my children just about 3 days ago. Did you know why? You remember that boy, Kelvin? Did you know how he was recognized again in Home Alone 2? Because of the name on the backpack. When those guys, if you can remember all the plot of the story again, when they came out of the supermarket, they saw the name on the backpack, McAllister. So, oh, this is that boy that put us in trouble. So they went after him. So ordinarily, everybody knows you should know your name, isn't it? Your name is readily everywhere. But do you now know that the name of Kevin did put Kevin in trouble? Because people know it. There was the story of a woman who had been looking for one home breaker or home wrecker. What do they call them now? Side chick. And it was because the side chick put her phone number on a register. And she saw it, she was there. And she now said, so this is this person. And the security guy said, yes, that is the person. And then, of course, she went after the lady. Just the name. So these are the issues. How much data, storage limitation. Now, another aspect is data confidentiality, integrity, and availability. That is data integrity. How many of us know the 5 V's of data? One V that should be a characteristic of data. But verify. A round of applause. So this particular area of data integrity, confidentiality, integrity, and availability is about data security. And there are 5 V's. I try to internalize them, but let's go over these 5 V's. Volume of data, you guarantee that through that CIA. We call it CIA. The value of data, you guarantee that through what? Through that same CIA. The velocity of data, that is that movement of data, you guarantee that through that CIA. The veracity of data, you also guarantee that through that CIA. The variety of data, you also guarantee that through that CIA. How many V's have we mentioned? Fantastic. Can we mention them? Volume? We should do convocation. A round of applause, please. You need to get this certificate straight away if we are going to. There should be place. There should be certificates of attendance. Yes. Even I know why I'm saying this. A friend of mine called me from Canada. No, these are people that were feeling proud that they left. And I'm by no means, he's a very good friend, but I joke with it. And he said, please, can you do something for me? I know you are in data protection. Can you arrange something so that I can add this to my skill? This guy has been over there. So if you have certificates from this that you participated, your value increases automatically, sir. Make no mistake. Let this not be another. No, this is not one of those. This is one thing that you can add to your CV, and your colleagues over there, whoever wants, maybe want to go for sabbatical, and they are now afraid because they have taught their own lecturers data privacy and protection. Go to any university in Europe. They are familiar with it. Go to US. They are familiar with it. And you are coming from where? You don't know anything about data privacy and protection. You want to do sabbatical? How will that work? It's a risk. So by the time they see that, it's a pointer that maybe so many things are right with these people. Do you understand what I'm trying to say? There are certain things. There is a signal that you will see that makes you to fall in love with someone, isn't it? That makes you to think there are some other qualities. At Ife gave us a lot of opportunities. So I remember, even when I was in part 1, part 2, I organized a master class. And MBA students participated. These MBA students now wanted to get job in Standard Chartered Bank. And because we gave him a certificate of economic intelligence, the interviewers only asked him questions about economic intelligence, not about the real certificate from the university. Why? Because so many people were carrying certificates. So they wanted something distinct. So apart from the fact that you are a professor, what else should stand you out as a scholar? Are we following? So that's particularly was the case. Please, sir, I'm pleading again. If there is no arrangement for it, please, we will endorse it. We will endorse it. Let it be part of their record so that they can use it. Now, going forward, accountability. How accountable are you? We have said that data belongs to who? The data subject, isn't it? They are the owners. And then as a university, you taught even these children, you taught their father. I remember when I was in Ife, there was a professor, emeritus professor, Professor Ijala is now late. He was taught maybe the second generation, not just the father, but the grandparents of the student that was coming in. Do you understand what I'm trying to say? So what would that child now tell that type of professor about accountability? Are we following? Is it possible? Look at the power dynamics. We feel so big. With all due respect, you are not accountable to your data subjects. But accountability is a requirement. There was a regulator that when we are trying to come up with, government agency, we are this, you are on your own, I'm on my own, don't come. I say, sir, when you go out there, how do you think people will look at you if you say you are the Alpha and Omega in your own this thing? You know you are not, you are the God. Nobody, you are not accountable to anyone. Who will do business with you? They want to transfer data to Nigeria. They now ask you, sir, Oga CEO, how are you going to handle our data? I am the boss. Anything I see on data is final. Who will transfer data to you? Because there is no guarantee of remedy. If anything goes wrong, you are the judge, you are the lawyer, you are the prosecutor, you are everything to yourself. So the same thing in the university. You must have that process because your integrity depends on it. It has nothing to do with whether you are the Senate or you constitute the Senate or you are the principal officers that you taught their grandparents. It is about your own integrity, that you have an accountable process in place. That in fact, you have a data protection officer that if he's doing anything, as far as data protection, it cannot be penalized. You can't sack him, you can't witch hunt him. You have set the procedure in place that gives room for, when they say fair hearing, it's from the pillars of natural justice that no man should be a judge in his own case. And that, again, that you do not condemn a man unheard. So that now gives birth to the ideas of consent and all of those that you must properly engage. So accountability is key. Accountability and duty of care. You know, I have said so much about principles and the idea of interoperability. And it is possible, sir, for you, for a judge to get lost in all of these jargons. Is that not correct? I said data minimization. Cancel, what is data minimization? How does it affect your life? What is data accuracy? I bet maybe they do the thing, maybe they do our work the way they do it. Is that not correct? But when we brought in the idea of duty of care, and the judge will say, yes, if he's using glasses, like this my guy will probably drop the glasses and cancel. So how have you demonstrated duty of care in this particular case? You can now say, oh, we have a privacy policy. We have a data protection officer. Our servers are well fortified. We have put all of this in place. We have a process of fair hearing. That is what you call what? Duty of care. And that is when, if there is maybe an applicant or a plaintiff or a complainant on the other side, he can therefore say, sir, no, this ABC University is not doing enough. As a matter of fact, if you go to DEF University, this is the standard of care. Are we following? For instance, you mentioned that university, Nile University. And thankfully, Nasarawa, what they are doing at the moment. And then I'm able to come and convince the judge that no, that is not the appropriate standard for ABC University. In fact, if you go to Nasarawa University, this is the standard already. And then the judge, the court will say, yes, you are not doing enough. You pay penalty. What is it? We'll get to the part of penalty anyway. But let me hint you, it's just 2% of your revenue. It's not too much, just 2%. Now go here, I'm from ASU. Is anybody from ASU here? ASU. We are all ASU. No, I mean real ASU now, not ASU. Professors are not really ASU. But my professor then, Jingo, was, well, I don't know, forever and ever, Aluta, So that is when you will hear it from your NASU, you hear it from everybody, because even 0.5% of what is not even enough is a big wahala. And it may come with a jail term. It depends. It depends. It depends. That will not be our portion. I'm not hearing amen. That will not be our portion. Hallelujah. So let's proceed. So, well, we have dealt with accountability. Let's talk about rights. Are we making progress? Are we making progress? Do we want to know about rights? Do we want to know about rights? It appears some of us don't want to know about rights. What are some of the rights that you should have, that you think a data subject should have? Right to privacy, that is the whole right. Yes, right to privacy. Right to privacy is like the map of Nigeria. With all, then you now have other rights like Sokoto, Zamfara, So right to privacy is encompassing. A round of applause, please. So what are those? It's like a basket. What are the other components of that right to privacy? Let me tell you something. You know the right to life. Now, they said it's more than you killing somebody. In India, for instance, they have moved beyond. When you deny somebody's source of livelihood, you are abridging their rights to life. If you doubt it, what is the average life expectancy? Pardon? In Nigeria, in a country, 65. 60 to 70. 55. Do you now see a relationship about right to life and conditions that may make you live longer or deny. In some places, the right to commingle, the right to read, the right to have access to basic things of life, necessities that make you a human, is considered as part of right to life. As a matter of fact, right to privacy is part of right to life. Some people can commit suicide. In fact, it has been done. Digital lending cases, embarrassment. People committed suicide because they were embarrassed unduly, scandalously. So if you take away right to life, right to privacy, you are touching life of a person. If they ask us now that everybody should now be walking naked, you say, make Kukuma kill me, Abi? Somebody will say, isn't it? For you to dishonor me, I'd rather die. There are people like that. That is the most honorable thing to do. If you rape a woman, for instance, the woman will say, why don't you just kill me? There are some like that. They won't be able to bear the shame that they were even assaulted or violated. Their privacy is violated. So what are these rights? Components of right to privacy. For instance, I said something about grades.
I would say the right to determine who accesses actually my data.
Fantastic. A round of applause. Yes. That is but let's continue like this. Then we come to where we talk about interoperability again, how to codify so that when we say if somebody is coming from your university to another university and then you tell them this is the right, he say, yes, we have this right also, isn't it? Madam, you are saying something? Right. Yes, fantastic. Consent, yes. Religious belief, fantastic. Access. No, yes. All right, don't worry, we'll get to that part. Yes, sir, you may.
We have cases, for example, where security agencies are mandated to dig into somebody's history, like school certificates and so on. In most cases, the consent of the holder of the certificate is not sought. So what do we do in such cases?
A round of applause for that question. Because even if I've forgotten what that I should take that part, I am now reminded again that it is important for us to take that part, especially when somebody also mentioned consent. Now, it is part of the principles when we talk about lawful, that you have to process data lawfully. I was coming to that. So I will answer your question in a bit, just hold it. Let's clear these rights. First, okay, you want to help us with one of them, right? Let's codify now.
Button is what you made mention of someone who is involved in student activism. And now it has a record, and that record is not too good. But after about 30 years, and the person wants to contest for election, the opposition party can use that record against him. So he can file a charge or whatever that is data. He has a right for that data to be deleted, for that data to be expunged from his record. So I just want you to explain for them.
All right, thank you very much. A round of applause for Ambassador. Let's serialize now. Let me even start with the right to be forgotten. Like I said, of my university, you know, there were some records. If it is just very, let's say, a felony, you know, you have misdemeanor, you have felony, you have maybe just something, 2 fighting team among students, all those things, they are really very common. And not something that should be kept permanently. But where you see maybe students kidnap their vice chancellor and kept him for the purposes of pressing home their demands, it is good to keep those type of people in view for as long as possible. But if it's just normal, we no go agree. a stubborn, stubborn student. Those ones. I shouldn't really go to, continue to transfer, he was seeking employment somewhere. I said, that boy, when he was with us, he was a very stubborn sharp. No. So there is right to be forgotten. Let me give you an yes.
Can somebody determine what should be deleted?
No. You cannot determine what will be deleted. The facts, the merits of the case. It is about what is fair. You know, we talked about fairness. Is it really fair? Pardon me, for those of the Christian faith, they said, if we can confess and forsake your sins, our God is just and fair to forgive us, isn't it? That's correct. So there are certain things that should be forgotten. Like I said, it's just something small that doesn't rise to the level of criminality. Because if you have a serious criminal record, not somebody who ran traffic lights, for instance, then he has a permanent. No, that's not the type of record police is expected to keep. In fact, there is a case in the United Kingdom where it was about running traffic lights. They said, no, you can't keep this type of record because they took biometrics. They took virtually everything. Why do you need all of this to keep permanently? Does this person or somebody who actually participated in one of these events, a protest, and then they kept his record? No, you can't keep all of these records like this. So there are cases that suppose rights to be forgotten. There was a case of a guy, he was in debt, and so the court ordered that his assets should be sold. In the case of Google, in Google Spain. And then this guy, after 10 years, the guy, or after a period of time, the guy became rich. But the record that he was a chronic debtor is always coming up. Anytime they put on his name, Gonzalez, they put it on Google search. What will come out is that this guy is a debtor. So he approached the commission then, their own data protection authority, that, look, I don't want this Google to be remembering me all the time. So he exercised his right to be forgotten. But the court said the newspaper can keep that right. They can keep that record for the purposes of record, but Google doesn't have any justification for continuously displaying that. Imagine if the name of a lecturer went viral for unlawful carnal knowledge of a student, and then anytime anybody searches, let's say which name, okay, let me use, I don't know what I'm going to say. No, I want to use a name that is really not from this Bolo. Okay, let's say Bolo. Maybe Dr. Bolo had this lesson, and then there are so many people bearing Bolo. Anytime you put Bolo on the search engine, they will say Bolo arrested. So imagine somebody going for visa. You are not the Bolo Bakura or something anyway. But anytime they put Bolo on the search engine, it's about arrest, it's about rape, it's about things along that line. Do you know that everybody now bearing Bolo will feel somehow? You know, there was a time that some people were calling Nigeria zoo. So anytime you are searching anything, Nigeria, zoo. Who is doing who? Tell me. Because those who should be affected, they have money to be protected. So you are looking for a job. You want to travel out. You are looking for a visa. Some people can buy the citizenship of another country. They don't need visa. You that we are calling Nigeria is you. Are you with me? It is you that zoo will affect. Because by the time anybody wants to engage you, it sees Nigeria is an animal. Do you now see the importance of rights to be forgotten? Rights of erasure. So you can approach Google for that. and say, "Oga Google, delete this record because of this outcome that we are having." Please, let's have you, sir.
Hello, sir.
There's some clarification
Yeah,
because
I have a
I was
little
thinking when we had
question.
SID for Africa. I asked this question
Hello.
that what happens to data privacy if the NFA implementing that, because if certain information should be based on consent strictly. If I'm an employer and I want to know the background knowledge, I have to have a background knowledge of my employee. I need to take a look at that because, but then since there's a capitalization of the information, the stages at which you get some information. So it's not everything that should be printed because it lacks regarding the individual. That no one can have an idea of who the individual is and have some knowledge.
So it's appropriate, but before anybody submits the application to you, a post referee there, it gives you a kind of tacit or constructive consent to do a background check. But then you can only release what is fair for you to do. Your opinion about that person is necessary because your vice chancellor may not even like you. And then he now puts his opinion as part of the record the reference is going to give on your behalf. All those ones are not your personal record. The only thing that is relevant are the things that are really concrete and that not something that other people really feel about you on the basis of what. I've seen people really denied admission on the basis of it was my faculty then. And the dean only wrote that that he is a better person. And then the Council of Legal Education now came back. Just a nuanced word. They didn't really say what that guy did, but that the university actually believed that this guy is, is a good guy now. But the way the Council of Legal Education took it was that that means something was wrong before the university could say this, even though the university was pleased at the end of the day that this guy should proceed to the university. And meanwhile, the Council of Legal Education of those days, and I believe even up till now, they still believe in what you call fit and proper. Fit to be fit, a fit and proper person. And I think even during convocation, I think some universities have that tradition that they are fit and proper character and learning. Is that not correct? So that is important to talk about this erasure. Anyway, let's proceed serially very quickly because of our time. There is a right, the right to be informed. The right to be informed, you need to be informed before your data is being processed. And that is when you look at your websites now, what information are you telling your students or those who use your platform or your portals? Rights to be informed. What are you informing them? The type of data you are collecting, the principles, your lawful basis, their rights to lodge a complaint with the commission is also part of what you should be informing them. And you should be informing them in the type of language that they understand. And I'm sure you are people who may have also struggled with the information that pharmaceuticals try to give you when you buy their drugs. Are there pharmacists? No, I don't think so. When you buy those drugs and then you see the indications and contraindications, and you cannot even read them. I mean, they are just too tiny. You can imagine an old man trying to read something that is so tiny. Meanwhile, it is too technical, you can't even understand, even if it is bold. Now they have reduced it. That means they don't even want you to know what they are saying. That's the truth. Because if this thing is that dangerous, then you should let people know in bold letters that these are the possible contraindications or indications for the drug. The same thing with data. Now, if you have a smartwatch or you have a phone that is collecting your data and sending it somewhere, how are they using that data against you? Do you know? How many of us have heard about Cambridge Analytica? You have heard about Cambridge Analytica. By many of us, we have heard about the Trump versus Hillary election. Can you remember? They manipulated that election to the extent that the election, because of this opinion sharing manipulation of the algorithm behind the way people share data, someone lost the election, another person won the election. The story of Rwanda is about data sharing. Can you remember? Hutus and Tutsis. It's all about data. The story about Sudan, Janjaweed, and all of those is all about data. The story about Jews, are we following? Jews in Hitler's Germany was all about data. In actual fact, it was about technology, IBM. It was that time that IBM came with the technology that can process data on a massive scale. You are all ICT. And then Hitler got an idea, so now I can identify my enemies. IBM didn't develop that technology just because he wanted, Hitler to be able to kill some other people. But at the end of the day, that same technology was used for that purpose. So it's good to inform them because of what? Because of it could have serious consequence. Then there is right to withdraw consent. Is that not important? If I have given consent for you to process my data, I may withdraw this consent at any point in time. Although, if some things are lawfully done prior to giving of the consent, that seems to have been done. So you have the right to erasure, that is the right to be forgotten. You have the right to withdraw consent. You have the right to be informed. You have the right
Hello,
of
sir. Hello.
feedback.
Hello.
Hello, is that a question?
Yes, please.
Go ahead, please.
Okay, sorry, if I'm taking you back. Right to forgotten and right to withdraw consent, are they the same thing in data protection? Don't be offended, sir. Thank you.
Do you want to answer from here? Anyone? Are they the same?
They are not the same thing.
All right, great. They are not the same. They are not the same. The right to be to withdraw consent.
Yes.
Oh, beautiful. I see where he's coming from. They look alike.
Yeah.
And to take
Exactly.
over. Yeah. I never thought of it. You can see now that we are learning. Because you have given consent before that your data should be processed, isn't it? Now you are with,
yes, sir.
Your data now should be erased.
Yes.
I mean, beautiful.
Yeah.
They are not the same.
Yeah.
Now let's learn now.
Okay.
Let's learn. This is beautiful. This is what I love. All right. Let's hold on, ma. Hold on. Yes.
It's not every time that you give consent. For example, the case of Aluta that you mentioned, it is not the wish of a student that that record should be kept. So the organization can forget about that. But in case you go to a bank and your data has been captured, then for example, or maybe in a school, let me use the university or any school too, there are certain things that you have given willingly, but as time went on, you felt it should be removed.
Awesome. I think, sir, let's proceed. I think that clears it, actually. All right. Okay.
Why the other one is both parties have to
agree. I think you can get the explanation. Right? For this reason, before I proceed with the rights, let me quickly run through the lawful basis upon which data could be collected. Before I exhaust the rights. Exhaust the rights? Okay, let's exhaust the rights. Let's exhaust the right, but this. Hold on. Let us finish. When we finish with the rights, please, can you mute him? All right. Okay. So rights of access. A student or a data subject should have the right access to his data. So that means for you, your data protection unit or the university must put in place data subject access request form that will enable people to easily access their data, not just for their students, also for the lecturers. You have seen an opportunity of a sabbatical that you want to quickly go for, and then for some reasons, they are not processing your data as quickly as they should. Then data portability is to port. That data should be able to move from one place to the other. You should be able to move data from one place to the other in a useful form. That means at the point when you are collecting your data, it should be what? It should be portable. It should be something that is useful on another platform. Right to withdraw consents, right to be informed, rights of erasure, rights of access. Yes, sir.
Our bosses upstairs, they talked about a possibility of you selling scripts, that you cannot be using scripts for Akara. You can't do that again. Yeah. Now, in a situation where students are expelled for poor academic performance, and the school decides to paste it maybe in their platform, putting their records, because there was give reasons why those students are being withdrawn. They put it on the platform. Is it right or wrong?
Thank you very much. There is a limit to what you can put out there. It should be sufficient to say that this person is no longer a student of this university for reasons of not being able to meet up with his academic requirements, the required GDP. But whether he failed, had F here or had so, it's not relevant to anybody. That is why we say data minimization. There is something on need to know basis. On need to know. Do I really, who cares whether he had 0.4 or he had nothing? Who really wants to know? Who needs to know that? No, sorry, sir. Let's proceed. What I'm saying in effect is that let us minimize data. There is principle of data minimization. Before, it may be necessary for you to post everything. But then the law now says data minimization. Minimize what you are putting out there. Is it relevant? Is it necessary for you to do all of that? So it is not one education you can take in a single class. But more and more, we learn about this. And by the time we are guided by the principles of data ethics as well, we say, okay, what do we really need to know? I mean, the academic community, what do they really need to know about this individual? Is this to be a student for this reason? If you are now the parent or you are the sponsor, you want to contend that, then you bring all the facts to the table. Because this guy may actually do better. He may even become a professor of the university at some point in time. If not a professor, he may endow a chair. And I want to plead with you. Let me use this opportunity. Who are the students that are most likely going to come back to the university to endow you? They are probably your third-class students and maybe 2-2 students. Universities are poor today because those that will help you treat them poorly. How many first-class students will come back to the university and give you? They will be brilliant lecturers. Is that correct? Okay, so let's proceed. That's not part of why we are here. But take that into consideration. Please. That's why you call it a universe. It's a universe. It's for everybody. It is not for the a few ways alone. It's a community. In Ife, for instance, I think it's a community of over 35,000 people. It has to be, everybody you must value. Every character in your class, you must value. Because it's getting to a point when, okay, you used to depend on government will provide everything. But now we can see in the case of University of Ibadan that somebody can donate 500 million. When I was in Ife, Andrew Carnegie, that maybe you've never heard of that name, gave Ife $2 million for a particular project. I think gender and just some small projects. $2 million of that time. Are you following? So let's proceed. We have mentioned data portability. They are right now to be subject to a decision based solely on automated means. Please, I want this class to be interactive and interesting. You are my Oga, so forget the fact that I'm representing the National Commissioner. You are professors. Probably I will come back to you for one thing or the other. So please, at any point in time, stop me. If you want the class to stop, that is where it ends. You have done well already. Hold on.
Thank you so much. I have a question on data tenure because we are talking about now students committing and the university keeping record of such a student. Yeah. So for how long, will that data about a particular person, the service, the organization or establishment last? I know in the United Kingdom, if you violate traffic lights for offense, they put a point in your driver's license, and it will last for maybe 2 to 5 years, and they erase it. In the US, when you arrive, and maybe you are staying in a place, they take a background check for 10 years or thereabouts. So after that, like here now, does the act in Nigeria make provision for data tenure? Because a bad student while in school can turn around to become, a very good person that can give an endowment to the institution. So does this act make provision for that data tenure? Thank you.
All right, thank you very much, Ma. A round of applause. You see, to be honest, in ICT law, we have a principle that you don't set specific standards or how do I put it? Not just timelines. You are not too prescriptive. Why? Because what is good this morning may change by the evening. If I prescribe, for instance, ISO 27701 as a standard for privacy, and then by this, as I'm speaking, they have even changed to ISO 30000. So that is why the law does not prescribe rigidly. It is meant to be organic, a living law that is relevant for all situations. And that is why you have a principle that just merely says storage limitation, depending on the purpose, why you are storing as much data as you are storing. So in the case of a student, for instance, like I said, if students kidnap their vice chancellor or any lecturer, maybe the lecturer they felt is too strong, they don't want him to conduct tests, and then they decided to keep him under lock and key somewhere, or threaten him as a courtist for doing his job. The record of such individuals should be kept in view for as long as possible. But in a situation whereby it is just a demonstration of disapproval, it may be that, okay, the timeline, why are you even setting the exams now? They were protesting, we have it's no light, like we used to do in Ife. No light, no water, you are setting, you are trying to set exam or what have you. This could, be record that you may not want to keep for too long.
Thank you so much. Let's make this a bit real. Let's assume Barrister Bangwe was one of those who picked Professor Omole because he didn't provide water and light on campus. Can such record now, assuming you are the student union secretary and you're part of those who led the protest then, can it be taken against you personally, or is viewed as student union action where you cannot hold anybody responsible, such that if you now apply to somewhere and then they are doing a background check on you, does the university have the right to then make reference to that act as being another person?
Thank you. This is $1 million question. Assuming all I did in the time of Professor Omole was just to join them to sing song for Professor Omole, that Wale o Sheba Yiloda Wale. How many? Which means, for those who don't speak Yoruba, I say Wale, so it has turned like this. You are one of those that organize a Aluta because of chicken. Now you want to, penalize students because of ordinary, we want water. If all that I did during that time was just to sing and make Professor Omole, our elder and Babalawo, to be happy doing his job, that shouldn't be used against me. But if it's involved something really causing bodily injury, as it were, in the manhandling of the vice chancellor, which should never happen, or principal officers of the university, these are also records that you want to. I think I even remember Professor Roger, when he was going to readmit some of the students that were rusticated, he said, no, it is important to give them chance again. So if you as a university, you have rusticated, and for some reasons, even as grievous as you thought it had been, and then you felt after some time that no, these people should have learned their lessons, let them go through the university again. And it is also important to make sure that they have the opportunity to attain the fullest of their potentials without being bogged down, because you have also forgiven and you have forgotten in even those instances that you may consider really very grievous.
Thank you for the opportunity. I have two questions at this stage. Number one is, it has to do with what you have told us already. Talk about purpose limitation somewhere along the way. So my question about purpose limitation, I want to come from the perspective of somebody with legitimate interest. Because somebody asks a very fundamental question about, for instance, people coming to ask about people's records and giving or not giving the information, it is the sole responsibility of the data controller or data processor, whatever. So is there a provision that talks about legitimate interest? Instances where, for instance, it is justifiable for a data controller to provide information about a data subject. Thank you.
Thank you very much. Have you heard this word before, legitimate interest?
Yes. No, yesterday when I took time to look at the law. I mean, yes, in preparing to come for these workshops.
Okay, that's good.
He doesn't want to tell you that he wants to contest for Senate in the, and the point that that in all elections, universities get requests that this man claimed that he attended this university, and we know that this university expelled him. He didn't graduate. And so universities should provide the records. And universities are usually very shy to provide those. And some people have gone to court to subpoena the university to provide those records. I think that is the point that I try to make, because it's something that we all have to deal with, especially in election years, local government elections, National Assembly elections, gubernatorial elections. Everybody wants to find out the record, whether this person attended that university, did this course, graduated with this certificate or not. So that clarification will really help this meeting.
All right. Thank you very much, sir. How many minutes do I have now? No. It is well. So let me finish this right. I will go back to address this question. There is I think related to what I should answer about your own question too. So do you have a right not to be subject to decisions based solely on automated means? I keep saying that it would be unfair, for instance, to say that those that admission should be based, or let's say employment should be based on, let's say, automated means, because you may have students from premier universities because they have so many of them. And that machine may have learned that university, ABU, like JOS, IFE, Ibadan, Uniben, and all of those, because they already have so many students who will be engaging with the computer. So the computer will learn over time that let me be picking students. If it's going to be based, it will now be picking from those who already. Meanwhile, those universities that were created, especially private universities, they may become disadvantaged as a result of that. We have seen situations where decisions based on automated means denied some people opportunity of insurance. Why? Because the computer could pick that there is something in the family background that may make this person become a burden on the insurance company, you know, or mortgage, as the case may be. So there should be opportunity for interference, of human interference in the, you know, in whatever decision that you want to take. Now, lawful basis. Lawful basis, as part of the principles, the lawful basis. What are these lawful basis? Number one is consent. Are there other means by which a university can process data without the consent of a data subject? Yes, there are. And what are those? Can you help us? What are those? Anybody? Pardon? Yes, just go ahead, sir. Yes. So, okay. I'm trying to get the perspective to this. Where you can have lawful grant. What is the lawful grant? Yes, you are pasting, but what is your lawful grant for doing that? Pardon? Senate approval, legal obligation. All right. Okay, so any other lawful grant? Yes.
Bailouts, the parents don't ever know anything. They keep on collecting money year in, year out. They are never finishing. They are never graduating. Now, in those days, they send those results to parents, and parents will get them and know the status of their awards. But now, schools, they tend to paste, and parents will not know whether their awards are in school or not. So I think that there's a lawful ground for going back to such ethics of sending these things to guidance, and so on and so forth. Thank you.
All right. Thank you very much. A round of applause for the contributors. All right. Please go ahead. Results. Very good. Fantastic. That's correct. That is correct. That is correct. A round of applause, please. Okay, let's move very fast. For again, like I mentioned, interoperability. I think we have over 130 countries now with one form of data protection regulation or the other, and we are meant to work together and almost have similar. And the principles and the lawful basis are similar. Now, how did we codify it in all of these jurisdictions? Consent is number one. Legal obligation, whether there is a law that mandates you to share that data, that is your lawful grant for sharing it. Then there is a contract in place. If you have a contract with the data subject, yes, of course, that's another lawful grant for sharing that data. Another one is vital interest of the data subject or of a third party. And what is that vital interest? Something like an emergency. God forbid something happens. They have to process data very quickly so that an emergency can be reached, can be given to the person. There, yes, of course, you can process data. Another aspect is the public interest. That, for instance, in this case of a university getting the request from what do you call it? From members of the public about a candidate. Yes, it is appropriate in the public interest if somebody holds himself or herself out as a graduate of a university. It is even in the interest of the university as well to say, oh, this was our student and he graduated at so point in time. And that should be all that is relevant. You say whether I graduate, I don't graduate now. Wait till you can't define again. Whether I fail or I no fail one course, it's not relevant to the purpose again. Are we following? So that is on public interest. Yes, you can process data. Then lastly, legitimate interest. Legitimate interest. Prior to now, we had a regulation, and it's still enforced though, to some extent, Nigeria Data Protection Regulation. Under the regulation, we didn't provide for legitimate interest. Why? Because we asked a question when drafting that regulation that if we want to process data, you said you don't need consent. Consent is not enough for you. You don't need legal obligation. That one no do too. Contracts, it never reach you. Public interest, you are not covered. What legitimate interest should you have in processing another person's data? If you can't get his consent, you don't have a legal obligation, you don't have a public interest, there is no vital interest, there is no contract. How are you processing the data? Husband and wife, and that's still a legal obligation. Part of your legal obligation is to do husband and wife, whatever they do. All right. So now, because of what you call interoperability, we want a situation whereby our laws will be on the same level with others. We now said we will admit legitimate interest, but with a caveat that before you can rely on legitimate interest, it must be compatible with vital interest, or either of these three: vital interest, legal obligation, or contract. For instance, I sent a request that I need my transcripts. You want to provide that transcript, isn't it? But then I only sent my phone number. You got the message, you didn't get the proper place to send it to, but somehow you could process my data and discover that I have a proper address that you can send this to. Then you can reach me, maybe through the phone, you couldn't reach me. Now you reach out to that address, we have this parcel for you. You know that now you are carrying out that because there is already a legal obligation on ground or a contract on ground to do something. That is, you are now going an extra mile. Or when we came here, you can see that they have, how many of you noticed this? This is a CCTV, right? Is this IP enabled? Sir, it's not IP enabled. Where is this stored? Who is looking at us as we speak? Your technical team. And who will have access to it as we speak? All that we have said here, does it record voice as well, sir? It records voice. So what are we going to do now? As this matter where we dey now? What do we go do? Now we go.
I think consent has been obtained because being nominated to be here and you accepted to be here is as simple as that. That your voice should not be recorded. Why?
This is a topical issue. Okay. Sorry, ma. Hold on, man. Let me speak with this gentleman.
Thank you, sir. Thanks for the wonderful presentation. No, sir. It's fine. I can speak. Yes, it's fine. So I just want to ask a question or clarification. We're discussing about data privacy and protection. And I noticed we have some cameramen here and those with personal phones snapping pictures and videos. And I can't remember we filled any form, maybe like, let's say a consent form that maybe videos and photos will be taken. And at the same time, this thing is happening. So I don't know. It's like we are not practicing what we have been taught now. So I don't know. Thank you, sir.
A round of applause.
Okay, sir. I think what we have seen here is not different from installing a CCTV in the system without informing them that you have a CCTV in place. If we cannot do it in a student hostel, I'm not sure it is good to do it here without informing us. Thank you so much.
Thank you. My question has to do with what is the relationship between data protection and human rights? And it is out of the question. During election, the Chicago was asked to release Tinubu's data by no problem, by an individual. So please, it's a question. The relationship between data protection and human rights. Can an individual go to my university without my consent and say they should release my data? As it happened in Chicago. Tinubu insisting they should not release it. Yes, it's true now. It's in the public domain. It's not a hidden something. He said they should not release his data, but the court compared the Chicago University to release the data. So what is the data protection all about today?
All right, thank you, ma'am.
All right, thank you very much. I think we're talking about the legality of the camera. For you to record live, you need to get the consent of the participants to say this program or this event will be recorded. And if you have that knowledge and you walk in, then you have given your consent. That aside, somebody was also talking about picture taking and all of that. I'm not very sure, but I think I've come across a law that talks about public space. I'm not in the legal, but public space, anything can be done. You can take pictures of people in public spaces. If you come out in public, then the public can take some form of level of recording. I am not very certain of that, but I know that there's something related to that. Thank you.
Right. A round of applause, please.
Yeah, I think on this camera thing, I saw in the invitation letter that people are free to join online. I saw a link that people were told to join from. And if that's the case, then you cannot have an online meeting without people seeing you or hearing what you're doing. That's for that. Then I want to ask you a question. Based on all this, is it proper to, if I have an F, a semester exam, is it proper to publish it for people to see outside me? Instead of sending it to me, you publish it on the board that the whole world will see it. Okay. That's one. Two, is there any difference between data protection and data privacy? Is there any difference? Again, on the okay, just one more. The issue of the right right to be forgotten. I want to know whether who determines records that should be forgotten. Is it the subject, or okay? Because it seems there are many things about a person that he wouldn't like people to know, or that he wouldn't like people to see. So can I wake up anytime and say, please, I want this so to be forgotten, even when the public wants to see it about me. Thank you.
A round of applause, please.
Thank you very much. Most of us are not lawyers, but I just want to find something. There's one intriguing thing I want to know. If a student commits an offense, robbery, tough student in the university, because we have issues like that, and after a long time, the university senate found out that this boy was becoming a nuisance. I said, let's gather around and let this boy leave the school. If they let the boy leave the school, probably means that they are forgiving him. Can that record still be cited? Can the student decide that since the university has, by implication, pardoned him or said that he didn't do all those things, can they still cite those particular records again against that university? Probably becomes a politician one day, because we have such cases.
Thank you very much. Some records you keep. Let me start with the last question so that we can deal very quickly with it. There are some things you keep because of defense of a legal claim. If you expel a student, you ask a student to leave, and maybe 3, 4, 5 years later, he comes back and said, why did you rusticate me? Why did you expel me? If you don't have the record, how will you defend the claim? So you process also for the purpose of defense of a legal claim, you can process data even across the country or beyond Nigeria for the purpose of defending a legal claim or the consent of the data subject, cross-border data transfer. As I have said, you look at the degrees of these offenses. You look at what is fair. And I think the university community or the average data controller should be properly equipped and properly knowledgeable about all that we are doing, so as to be able to make the judgments when it comes to what record should it keep and what should it delay. It is not something that you should do if you have truly forgiven. That doesn't mean that the record should not be there. If in future something can come out of it. But records that didn't really lead to rustication, just a question of some people who are not happy that things were just, they demonstrated and not really, they are not vandals. As is why they didn't vandalize, didn't commit any arson, like burning down school property, destroying all of those things. Just people singing like we used to do so much in those days. So just to sing and just make sure that there is something called civil disobedience. Yes, something, acts of maybe civil disobedience, which is allowed. And then, of course, there should be a limit to what we do with that. The relationship with human rights, of course, data privacy, as I said, is founded on Section 37 of the 1999 Constitution, as well as other protocols such as the Universal Declaration of Human Rights and International Covenants on Civil and Political Rights. That's the relationship between privacy and protection. A lot of people ask this question, and I really don't know where that question is coming from. Truly, I really don't know why people ask that question, but it's important because people ask this question a lot. But I will tell you that when you look at Section 37 itself, I will try to paraphrase, but this is how it starts. It says the privacy of the citizen what did I say? The privacy of the citizens, their homes, their correspondence, their telephone conversation, their telegraphic information, the rights of citizens to privacy, rather, the rights of citizens to privacy, now is hereby guaranteed and protected. So the privacy is the right, protection is the duty. Are we following? Because I have a right, that is why you have an obligation to protect that right. That is what the law says. Nothing more, nothing less. So there is no need for really saying that duty is bigger than the rights. Which the argument that sometimes people tend to make the argument that that duty is bigger than the right, or the duty is different from the right. Now that duty now also becomes my right. That you should protect me also now becomes part of that right. It should be protected. Under international law, we call it positive obligation. Positive what? Obligation. If you say, for instance, the rights of a citizen shall not be taken away, that is a negative obligation on the states. The rights of the citizen, the right to freedom of expression shall not be restricted. Negative obligation. The rights of the citizen to expression shall be protected. Positive obligation on the states. So that right to be protected is a positive obligation on the part of the country, and that led to the establishment of the Nigeria Data Protection Commission, because it has a right. It is not Nigeria, it's not the state that gives rights. Hello? Hello? That right that we are talking about today is not from government. Where is it from? Who can answer that right? Who can answer that question? Where is that right from?
I'm not sure.
Who can answer that question? Where is the right from? Yes, sir. No, not yes, it's from the Constitution. But before the Constitution, the right was there now. So where is the right from? It's from where? It's from God. It's a natural right. It's an inherent right. That's
right. Yeah.
Right. States don't give rights. What do? States recognize.
Implement.
Thank you. This act, this Data Protection Act, vis-a-vis staff interdiction and suspension. How does it go? I will explain what I mean by interdiction. For a staff member who has committed a criminal offense and is placed on interdiction, thereafter investigation, this staff is now let go or sick. In the system, this staff is now advancing, wants to get to a particular position. There will now be that clause that, Mr. Lagbaja was interdicted, but he was left off the hook. Do not give him this responsibility. Maybe administrative position, that is one. Two, a staff member on suspension. Maybe he has also been found wanting in one area and is suspended for probably a month or two. And in suspension, you will not be paid your salary. Stay off work, then after investigation, you come back. What is the position of that protection act for these individuals? Taking into cognizance the issue of pardon post conviction. You know, somebody is convicted and you now say he's in pardon. He's coming to vie for a political office. They are still using that against him. What happens to that data protection of these individuals?
Thank you very much, sir. like I said, I think even if, sorry, sir, you want to say something about SP? Or another question?
Yeah, because what we have here is Nigeria Data Privacy and Protection Act 2023. 2023, right? It's not specifically for the universities. I'm coming to his question. My understanding of what we've been doing here is that this is to expose us to the general act which governs whether university or business or company. This is Nigerian Data Protection Act 2023. So what I'm thinking is that some of these specific issues we are talking about, Senate is an organ that makes rules and regulations for the university. So my understanding is that having seen the bigger picture, we should go back and guide our Senates in making rules and regulations for specific issues. One, bearing in mind that we should not infringe on any right already granted to any member of our community or any member of the university community under the 2023 Act. And then also leveraging on the rights that have already been contained in this Act to make rules that will help to move our university forward. So like the issue of whether results are going to be published on notice board and things like that, it is for the Senate to decide, bearing in mind what this National Act have said. From there, we may find justifications for us to publish results on the notice board, because that's also leads us to the issue of the data subject. Because I'm also seeing a situation whereby there may be dual ownership of data. The student that we are publishing the result is on that student. But what about the lecturer who or the department that organizes the exam? They also have ownership of that. And the Senate, yes, the Senate may require me now as a lecturer and say, please teach Mathematics 101 and then give me the results of students on that. So that becomes my data too. And Senate is expecting me to supply that data. So the student cannot say that, look, giving out information. Because as a lecturer, I'm supposed to have custody of that data and then produce it to Senate. So my understanding is that you are giving us the general background, unless you are telling us
We also review that
that there are
company
Nigerian
share
what I'm seeing.
recommended 100.
Thank you very much. A round of applause, please. Like as he rightly pointed out, the act is general, is the overarching law for you to go back and be guided by the act. If you do anything outside the act, that act becomes ultra virus. It becomes illegal for you to do. Let's get something straight. Ownership of data. Well, you can discuss it in a loose term that everybody owns the data, whoever is in custody or it participates or what have you. But in technical terms, only one person owns that data, and that is the student to whom it relates. You are in lawful custody. The fact that, as a matter of fact, the fact that somebody is even in the custody of data, it may even be to the exclusion of the data subject. Are we following? You could have proper lawful custody that you will not even release this data to the data subject, but that doesn't even make it yours. You are only entrusted. You are only entrusted with that data. The law says that what the law recognizes is that there is a data subject who owns the data. The lecturer is not the data subject. Is he the data subject? It can only be the data subject to the extent to which his name appears on any of the documents. Even if we process the data, that data relates to a data. Is it the data subject? No, you can, yes, it is still part of the consent for coming into the university. I've given consent that I will be bound by the rules of the university. Period. You send the result to this. If you don't send it to the Senate, how will I graduate? That is understandable. Senate must approve. But there is a limit to which Senate can, treat that data. They cannot, for instance, if, let's say, some people are doing documentary on academic performance, and because you said you are the Senate, you are the owner of the results, you dare release students' results for documentary. That one, our wahala. Big wahala. And before now, we have been seeing people who, we are universities, like even in my days, they publish the results on notice boards where you go and see. But then, it has become necessary because of human rights, because of the implication. What if somebody commits suicide because of the fact that you have published his F or otherwise? These are things that society now begins to take into consideration. That there is what you call, in fact, part of human right is the dignity of human person. By the time you begin to do that research extensively on human rights, this data private, no, not even just human rights, rights to privacy is what? Dignity of human person. So when you are handling data, you are not only thinking about the privacy, you are also thinking about what is dignifying. Please, let's exhaust this class. I've been warned that it will be, you will have a lot of questions. Are we following? So you must keep that in mind, because at the end of the day, you can have a lot of issues to deal with, especially from those who believe that you have treated their data unfairly. Please go ahead, sir, if I don't.
Students that have F, there are some universities in Europe, when their results are pasted, it is only those who passed that their names will appear. Once your name didn't appear, it means you failed the course. I think that one falls under the data protection. Or is it under the right to privacy? Because for quite some time, it has been a very good, big argument that publishing those failed is embarrassing to them. So as a result, they don't want it again. Once it goes to the board, you don't see your name, it means you failed. It is not a question of missing results. It's quite simple, you failed. So,
all right, sorry, sir, because of time, please.
kind of person if you say he fail, he go carry in portmanteau, go back. Why? Because he has already built in over time. For me as an individual, and I don't know what you can do to me, even a sack. It will just anything, it will look like a boost. To tell you what happened, like I can give you my own story. I was in the university in 1999, 1998, 99 to study law. I left that university because another university gave me admission because of my A levels, gave me admission to a higher level. When I got to that university, around the same 99, the university vice chancellor told us, it was the dean faculty of law, said, look, I am back, because he went away that if you don't have mathematics, you cannot read law. What do you think will happen to an average university student of today? I lost that admission. I went first. We went with Gani Fawemi. We took the university to court. We almost committed the vice chancellor to prison. And the vice chancellor said, you cannot say because your uncle is the vice chancellor that he should waive. He was also a very strong man. So we got a court order for us to be, for our studentship to be reinstated. But the man now said, if you came in with court order, you are going to graduate with court order. Because of what? No mass, no law. Please, since I've been speaking with you, does it look like this person no law, right? I mean, no mass. How does it? But that is the opinion. You know what we call Senate rules? They are just opinion of one or two the lecturers who are vocal in the Senate. And then it becomes a rule for the university. Honestly, it's everywhere, not only in the university. Go even in Congress, in parliament, in democracy. There are Senate rules. But what is the purpose? Now tell me, a university agrees. This time I already told you, before the man became dean, faculty of that law, that school, there was nothing like no mass, no law. As a matter of fact, the direct entry form I filled said I didn't need law. I didn't need mass. That was the basis of going to the court. And the court said, yes, you have a right. As a matter of fact, the lawyer of the university, and that got us angry anyway, the lawyer of the university told the court that university can do anything. That is the Senate. In fact, they quoted the Senate as you are quoting the Senate, sir. That this is the Senate, and said the judge now asked, sir, do you mean that if I meet all the conditions, the Senate said you are too black? Because the judge was black and said you can't be a student. And the lawyer said yes, because the Senate said so. Roman Lakuta, Causa Espinita. So now the court said no, court of equity will not permit that. But when the university, they had power. At this point, the dean of the faculty also admitted or is a member of the Senate. Everybody in the university, in fact, a king was among the deans. So, mature students actually were doing a dean, a registrar that had been in the courts for how many years, also wanted to study law. PhD students from the University of Ibadan wanted to study law. You now said mathematics because you are the one. And that's the Senate. So we know how it works. So what happened? To cut a long story short, I left. I said, instead of waiting to give me court order, I will leave. So what did I do? Somebody who was already should be going to 300 level, I had to take JAMB to enter University of Ife, who would accept me without mathematics.
So what is the scientific basis for that decision? Now, but then, why am I saying all of this? Relate it because of what I had passed through as a person growing up. My generation, not just me, my generation, what we passed through. An average person who could struggle to enter university still make something out of university. Today, our children, as they are, my child cried. I had to console him because of Côte d'Ivoire lost. An 8-year-old boy. Côte d'Ivoire, I can't sleep. I can't sleep at 12 o'clock. I can't sleep. And what will I do now? Are you Côte d'Ivoire? I mean, because Nigeria lost to Côte d'Ivoire. Are you following? Because the environment is different. What they are passing through. So also your rules must change to reflect the circumstances. They now have a right. Dignity of human person comes into play. Their data is in your hands. Everything is in your hands. Data is like life. For instance, as we are seated here, you may have made transactions of over 100 or 200 million naira. You never saw that money. The amount of money you have spent actually through your phone is more than what you have touched physically. That is correct. So your land is in the registry. Somebody can change it on the computer and say this land doesn't belong to you. You can get to VIO, the particulars of your vehicle ownership has changed. So on paper, that vehicle ceases to be yours. When police meets you, check their record and say you are driving a stolen vehicle. While I don't start. Can you now see when you come back to the issue of the election that our professor mentioned the other time when they had to go to University of Chicago? Can you see how something that happened in the 1970s, how it can come up today in an election matter? But the US, they have even a law guiding students' privacy. And so there is a limit. The students had to be heard. The course of action, the locus, that is the standing, the legal standing of those asking that question, because it was relevant to election matter. This candidate had said that he did this, he did this, he did that. But under the law, there is also a limit, unless there is a political interference or there is a political, inclination. And in the US, you cannot rule that out. If you're a Republican, you know the kind of judgment you are likely to get from the Supreme Court of the United States. If you're a Democrat, you also know the type of judgment that you could get based on political theory, not necessarily on jurisprudence. In fact, that's their own jurisprudence. So please go ahead, sir. Time, right?
We hide the names of the candidates. So that will reduce the social pressure, the whatever we're talking about, the societal thoughts. And so it's difficult to understand, to know who particularly is affected. And then we mentioned the withdrawal cases as well. But then we also issue the students with slips. And this is in their own accounts, their dashboards. So they can actually print out their slips. Now, in that case, transparency was actually implemented in that sense. So it's a ledger system. Now, both the Senate and the students who own the data and the faculties have the same record. So in case there's any infraction anywhere, it's easy to trace who is actually at fault. Now, the reason why also we publish it is because sometimes the students, they have cases where they pass a course and then all of a sudden the next year it appears as a failure. So now during the publication, they know which courses they passed before. So to avoid victimization and all sort of stuff, we allow that to take place. So I would suggest that after this, if some sort of a committee of the universities can work with you and form one that will adopt or create an adoption of the act that is suitable for academic purposes. I think that way it will work for us. Thank you, sir.
A round of applause, please. In actual fact, not to belabor this issue too much because of our time, don't let me be the one standing between ourselves and if there is a launch, as the case may be.